Good afternoon, everyone. Thank you for joining AMPC's webinar today. It's the first part of a four-part series in our work, health and safety webinars. And today we're lucky to have Simon Booth and Andrew Douglas to talk to us about terminating the employment contract. For those that may be new to the industry or are not aware, that this has come about from some of the recommendations from a project that AMIC conducted on behalf of AMPC 2 years ago, in terms of being able to help upskill and give people some further detailed information to help them in their daily businesses. So while we're waiting for the last couple of people to join in, I just thought I'd go through a few housekeeping rules so that you can understand how this program works. So we're using GoToWebinar. The attendees are not able to speak, so you can't directly physically ask either Andrew or Simon a question. However, there is a section under questions where you can actually type a question. And what we will do is we'll actually be able to forward those questions to the presenters and they'll be able to answer them as we go, or if we run out of time, we'll make sure that all the questions are answered and we'll get back to you. There is a survey at the end of this webinar. Really encourage you to give us feedback. We love feedback. That's the way we improve these webinars and how we interact with our members at AMPC, so really appreciate if you can stay on to do the survey at the end. And you should have all received a handout that's been emailed to you. I note that one person has only just sort of registered, so I'll send that email to you in a minute. If anyone hasn't received a handbook today in an email that I sent at about 20 to 2, if you can just put in your question bar now that you haven't received it, and I'll make sure I email it straight out to you. So without any further ado, thank you very much for attending today, and I'll hand you over to Andrew Douglas for an introduction. Thanks, Andrew.
Thanks very much, Amanda. I might just go to the first slide just so that you know who we are. Simon and I will be presenting today. I'm a workplace lawyer and I've worked in the meat industry as one of my key industry groups for about 25 years, and Simon is a specialist around risk management, workers' compensation, and he's the person who was involved in doing the AMIC study around meatworks, and it's a major portion of his practice as well. So the two of us are here today talking about terminating the employment contract. Simon, you're online, are you, mate? Because I can't see you here.
I am here, Andrew. Yes, indeed.
Yeah, goodness knows what the background is that you've got. What Simon and I have done is we've prepared a workbook for you, which is what Amanda sent out to you, and that's like a school book. So please use it like a school book, go to it and use it as a resource. It sets out everything that we're going to talk about today. It gives you some working examples which are live within the meat industry, drawn from Simon and my experience in the meat industry. So it gives you some tools to go back to your managers and say, this is a bit like the example in Andrew and Simon's book, and this is the problem with it. And it's got some questions there for you to be able to ask yourself and say, look, do I understand what's in the book? And the answers are also there at the bottom so you can find out. But again, it's a really good resource that you can use for you and other people to understand how do I manage people? And if they're not behaving well, or if they've got a problem with their health, what do I do about it? And it should throw up for you a lot of red flags so that you know when you're about to do something, maybe I shouldn't do that. Maybe I need a bit of advice at this stage. Maybe I need to think about it a little bit more. The presentation today falls into two core components. The first one is talking about how you manage people. It's talking about the actual practice, the human resources practice behind how you manage it. And it's connecting that in with the laws. So you understand when, as you as an HR person say something, you understand why you're lawfully able to say it. And I guess importantly, why you're lawfully not allowed to say some things as well. It also shows a very simple structure of building a people plan within an organisation to maximise productivity within the organisation. All of us are used to line speed in the meat industry, and line speed is and one of the best known productive tools that you can use. But how do I get the right line speed to have the maximum productivity and the maximum quality with the least amount of bad behaviour and injuries? That's what we're really talking about today. So that's part A of the process. Part B, we look then at, well, I've got to discipline or counsel somebody. What do they mean? And how do I actually do it? And how do I do it safely? In other words, how do I do the right thing and then end up with the right result, rather than somebody who does something wrong, I don't get it quite right, and suddenly I'm stuck dealing with the problem of having to reinstate that person or spending a lot of money in litigation, because although I was right about the wrong behaviour, I was wrong about how I managed them. So this is a pretty good guide. I'm an old guy. I've been doing this for a long time, and I've been involved in lots of the cases where things have gone right and wrong. So I hope that you enjoy what Simon and I are doing today. I'm going to draw Simon in more when we get to the issue of managing people with injuries, because it's certainly his area of expertise. And we understand in the meat industry, there's 2 or 3 key issues that happen. Most large meat industries deal with a workforce who are pretty hard working under difficult environment, but are often badly behaved, both inside and outside of work, and there's a need for you to immediately intervene. So that's a really big issue. The second issue is there are lots of cuts and injuries that occur just because of the nature of work in it. How do I manage people who are injured and don't want to come to work? When can I terminate someone's employment because they're not fit for work? We're going to deal with those questions as well, including the process that sits around it. So let's go on to the next slide. Here we go. So let's start with managing employees. These are the questions I want you to understand. I want you to apply these tools constantly. How do you define what is good behaviour? Okay, because you can't define bad behaviour until everybody who leads in your business does know what good behaviour is and leads that good behaviour. The second part is every HR problem comes down to 3 issues. That's clarity, capability, and commitment. For people to be good, they need to know exactly what they're doing. So they need real clarity. They need to be competent and able to do their job correctly. And capability includes the physical capacity and psychological capacity to do it. And they need to be engaged and always deliver 100% to the organisation. That's commitment. And usually the problems we deal with people fall into one of those 3 categories. So I might just move on to the next slide. This is the structure upon which we're going to talk to you today in managing employees. So this is a little thing that I've created. I hope it's useful for you. It's the why, how, what triangle. We go first to look at the why part of it. And the why part of it is always, what is the business purpose that exists? Now, the important part about purpose is most businesses don't explain what it is. In business, in meat industry, it's always to safely, precisely and hygienically process meat for the wholesale, domestic and export market. That's usually what the purpose is. Now, why is that important? Well, it describes to you exactly what must be done. There must be high levels of safety. There must be precision in the cutting and managing of the animal. It must be done hygienically, okay? And you know exactly what your market is. So the first part of understanding the why is knowing what is the purpose. The next part in why is saying, so what is the business plan? How do we measure success in what we do? That seems pretty straightforward to most people, doesn't it? But the truth is the only indicia that most people know in a wheat meat works is line speed, okay? They don't understand the other key performance indicators. People work better when they have clarity around what does good delivery look like, okay? So being clear and consulting with people around what are the goals that have to be achieved, what are the standards and expectations, that's really important. And the last part, and for Simon, this is the most important part, isn't it, Simon? Job description. Simon can't help you if you get a workers' comp claim if you've not been complying with someone's job description. The job description must accurately describe both physically and psychologically what the person is required to do and is capable of doing, okay? So we must know with clarity what they're doing. We must know the capability that is required of them, and we must know the output that will be delivered: clarity, capability, and commitment. Now, the problem is when we look at your work, you'll probably find there's people who work at 60%, some who work at 90%, some who hardly work at all, and we pay them all the same. Their job description, therefore, isn't relevant, isn't it? Because what they do at common law, which is what the courts use, is what you've allowed them to do over a period of time. If you want to improve productivity in a business, get everyone working at 100%. That's a really good start, isn't it? So let's just go back up to the pyramid again and have a quick look at what the next thing is. So how? So I know why I've got someone doing something. How do I get them to work the correct way? Well, the first thing I do is I define with absolute clarity what are the values in the business. Okay. People think that's a bit of a joke, you know, it sits above the receptionist's head. These are the values of the business, and nobody honours it. And that's simply because the leadership group are not committed to that. But when you sit around the dining room table with your family and you look at your children, they know what you think is good behaviour. They know what your values are. They will be honest with you. They'll eat with good manners if that's what one of your values are. They'll be respectful of older people. In your family, people know what it is. Good and bad behaviour is absolutely clearly understood within a family. If we don't define the values of our organisation, people will apply their own. Okay? I want to just use a simple example. When my youngest and most dangerous daughter was 17, I said during her VCE years that she was not to go out past 10:30 on a Friday night. She could have a couple of drinks, but she couldn't get drunk. All right, that doesn't sound too bad, does it, for some of you? Some of you will go, you let your teenage daughter with the effect it could have on a brain drink, very bad. They're your values. Some of you will say, isn't it her decision at 17 whether she gets home at 10:30 or 2:30? Some of you say, well, how did you manage her safety? Because when we apply our different values, we come up with different decisions. The values are the window we look through on how the people in our organisation behave. So if I use a word like integrity as a value, I've got to actually describe what the behaviour of integrity is. That is, always acts honestly, is always accountable for their actions. Why? Because if I want my supervisor to lead the values, they must know the behaviours that demonstrate those values. When you do that and you put it into your code of conduct, and structurally, your code of conduct sits up above your policies and procedures. If you don't have it, get it, okay? Create a code of conduct that describes what is good behaviour in a business. And that will include the values. And the reason for that is if I'm dealing with Simon and he's misbehaving, I need to go to a source that says what is good behaviour. And I say, look, Simon, I'm looking at the code of conduct. And it says you must act with integrity. Your obligation last night was to move 2,000 animals through the site. You've actually only done 1,600. And we've had people not working at all during the last half hour. Integrity says you are accountable for the level of production which you're meant to deliver. You didn't do it in accordance with the code of conduct. Now, the code of conduct forms as a matter of law, and we'll talk about it later, lawful and reasonable directions to an employee. When an employee doesn't comply with lawful and reasonable directions, they're guilty of serious misconduct that can lead to the summary termination of their employment. So it's pretty important, isn't it? Okay. So get your values right. Don't have 45 of them. Make sure you've got 3 or 4 of them. You'll find them, they do sit just above your receptionist's head, and they are totally ignored by everybody. But as an HR person, re-enliven them and say, look, if we want to manage people, people have to know what good looks like. They have to know that this is what good behaviour is. The amount of time we deal with senior supervisors and stuff behaving badly to employees and having claims for workers' compensation, and at an average meatworks where the insurance premium is somewhere between $400,000 to $500,000 to $2 million, maybe upwards of that. If a supervisor behaves badly to an employee and they put in a stress-related claim and don't come back, it may cost you somewhere between $300,000 to $400,000 to $1 million. That's all because you don't honour your values. Does that make sense? It's that simple. 2 or 3 good conversations done correctly prevent a claim that's worth somewhere between $200,000 and $1 million. God, it's not hard, is it, to produce a code of conduct and actually behave like that? The next part is we need employees to know what the values are. We need them to know what the code of conduct. Every day when we direct people to do stuff, it must be through that lens. In respect of the policies and procedures that govern how people do things, not just safety procedures, but all policies and procedures. The supervisors around that group of employees must know and own those policies and procedures, because you can't have a system of work where the leaders are not competent in what is good behaviour. All of you as HR people and operational people will have employees walk around their supervisors and come to you to try and get answers that relate to the supervisor's accountability around policies, procedures and code of conduct. How crazy is that? What's happened to the supervisor? They've just lost all power. So if you're going to spend some money on training, spend on your supervisors, being really clear about what good values look like, being incredibly clear about the code of conduct so that they can utilise it as a document to govern the way people behave, and to know the relevant policies and procedures in their place. They've got to be the experts. They are the oracle. They are the place that people go to find out information. Because once people go around them, to HR people, to safety people, to operational bosses to get answers, they lose all their authority and then they can't drive good behaviour. Being a leader requires ownership of what is good behaviour, and that is the role of leadership. And the last part is many of your businesses will be owned by families. And there'll be many generations of family who are involved in that. And it'll commonly go back to a dad or a grandfather who's known to be an extremely tough individual and is a very direct person. Can I just say, our workplace relationships have moved on from 30 or 40 years ago. I should know because I've been there, okay? And I started working in a meatworks when I was 17, and I'm a lot older than that now. As leaders, we have clarity around what work needs to be done. We are mindful of what is the capability required to deliver that, and we're absolutely committed to that outcome, but we do it respectfully. So if we want to manage bad behaviour, the first thing is that our leaders don't behave badly. And there's more than, the obvious one is if they do, other people will do it. But the legal problem with it is the thing called the doctrine of condonation, which says you can't punish that which you'll permit. So if one of your leaders behaves badly, that's condoning bad behaviour. So if then one of their employees behaves like that and you want to terminate them, and they point back at the supervisor, the manager, the family member who was involved, the Fair Work Commission won't allow the termination to succeed, because it'll say you condone it. You can't punish that which you permit. So let's go back to our triangle for a second and look at the last category, which is what. Okay, so what is the legal framework? And a lot of what we're going to talk about today is actually going to be around the law. And I know that's not that exciting, but I think that's why you came along. So we are going to talk about it, okay? At the very bottom of the law, the thing that holds all the law together is the common law. That's the law made by judges. Governments then come over and they overlay what are called statutes upon the common law, and that can modify the common law. I'll explain how the common law is modified in statute as we go through. The statute then permits documents which come from statute and have the power of statute, and they're enterprise agreements and awards, okay? And they prescribe minimum terms and conditions which you cannot go beneath. And if you do go beneath or breach them in any way, it is a civil penalty offence. And they're significant, they're about $10,000 an individual and around about $60,000 a business. So getting it wrong means you end up in the federal court with an enforcement proceeding. The meat industry union is not a tough union. Has its moments. The AMWU, who many of you work with, of course, because of the maintenance area, they can be a really tough union. But all of them have brought meatworks to the federal court and the Fair Work Commission for award and enterprise agreement breaches. Don't give away easy wins, okay? That's done. So very important that your supervisors and managers clearly understand how the enterprise agreement or the award works. They need to know what the statute and the common law is. I explained that pretty easy too. There may be some modification of awards and enterprise agreements through contracts, okay? Make sure your contracts are up to date and they're right. And finally, policies and procedures, of course, are your directions to employees about how they are to behave on work, and the top of the policy and procedure is your code of conduct. Let's go and have a bit of a look at common law, just so that you can understand what the common law is. At common law, the courts say that employees must be obedient. That is, they must comply with lawful and reasonable directions. That means around your policy development, it's pretty important that you absolutely describe what people are required to do. And it's very important that your supervisors and managers know this. All right? We sort of have it in our normal environment. We know we're not allowed to drive through red lights. We know we're not allowed to speed. Now, that probably hasn't stopped me, but then I've lost my license a couple of times, and that shows what happens to people who breach lawful and reasonable directions. They get into trouble. But if you're not accurate about what is good, you're not able to manage bad. So once you do identify what is good and a person doesn't comply with that, it is a breach of a lawful and reasonable direction. At common law, that's a fundamental breach of your contract of employment. We'll see that's modified by statute shortly, because statute says if you don't comply with a lawful and reasonable direction under Regulation 107 of the Fair Work Regs, it's serious misconduct. Okay? So like, this is really the backbone of how I manage somebody.
I'm listening.
Oh, sorry, that was Siri just having a bit of a chat to me. I'm sorry about that. I think Siri needs to shut up, actually. Put Siri down over there. I apologise, Siri wasn't meant to be on this presentation. The next duty is of good faith and fidelity. Good faith means for people to act honestly and in a serious manner for the best interests of the business, which comes next. So in other words, when people come to work for you, they must be honest, they must be sincere in what they do, and they must always act in the best interest of the business. So standing around scratching your bum and smoking a cigarette when you're meant to be in work is not in the best interest of the business, okay? Not cutting meat correctly is not in the best interest of the business. Throwing meat product around is not in the best interest of the business because of the hygiene rules. Do you see how powerful the common law is? Because what it's saying to you is, oh, look down here, I've got to be competent, careful, and committed. That means that people must exercise the competence that is expected from them. They must be careful and manage in the way they do it, and they must commit their time to the organisation. Isn't this great language that we can use when we manage people? Okay, so when someone's not performing up to the expectation in the job description and you are managing through the job description, what do we know? They're breaching their common law obligations to the business. Now, if a person doesn't act in the best interest of the business, they're also breaching their statutory obligations. But it's very important supervisors know these things, isn't it? Now, the last part, of course, is the common law assumes people will be fit for work. And we know that safety legislation in all jurisdictions has said that an employee must exercise reasonable care. That's a competent person doing their job correctly. Where do I find out what is correct? I go to their job description. Do you see what, here we keep coming back to it, don't we? Where do I find out whether someone's fit for work? I go to their job description. Where do I find whether someone is doing their job correctly? I go to their job description. So it's no good having a 2007 version of a job description that's not true. It's pointless. When someone injures themselves to work and I go to a doctor and I say, I want you to return them to work, and the doctor says, what's their job? Where do I go? I go to their job description. When someone injures themselves outside of work and we're trying to adjust them back into work, and discrimination law says we must make reasonable adjustments to the inherent requirements of their job. What are the inherent requirements of their job? They're spelt out in the job description, okay? So under safety law and the common law, the obligation of the supervisor is to be satisfied that a person is fit for work. That is the obligation that sits on the supervisor for the employee. They must talk to them, observe them, and be satisfied that a person is fit for work. If they have any concerns, don't let the person start work. They have a deeper conversation. Now, I'm not suggesting that meet work supervisors and managers are psychiatrists, far from it. I'm not suggesting that they have high levels of personal skill around having what some people call difficult conversations, what I call the conversation you're legally obliged to have and you've got to have. But they can certainly say these things. Look, I saw you work through the door and you're limping. Have you hurt yourself? And the guy says, no, look, I'm fine. Well, no, you're not. I'm going to need to get you assessed by a physio. Or let's see how you work, but let's not do any lifting for a while. I want to see whether you can do it. That's the obligation to supervise. Now, the common law also says that obligation sits on the employee to disclose whether they're fit for work. Think of the things that may prevent a person from being fit for work. Drug and alcohol consumption. Fatigue, haven't slept the night before, was arguing with my partner all night. I've got an injury, I've hurt my leg, I'm feeling unwell, I'm psychologically really struggling. Okay, most of those things I can't know unless I talk to a person, can I? I can't know the person's fatigued unless I look at them and say, God, you're looking a bit tired, we were up all last night. Yeah, the baby just wouldn't go to sleep. Am I seriously going to allow someone to use an incredibly sharp instrument who is affected by lack of sleep to the effect that they're over 0.05? I don't know about you, I'm not going to let it happen. How do I know whether a person is affected by drugs or alcohol? If I don't look at them, if I don't connect with them, and I find out 4 hours into the shift that the person is asleep underneath a saw bench, a bit late then, isn't it? Okay, so the common law is saying this is an obligation on the employee. Safety law says this is an obligation on the employee, but why don't employees tell you? Well, they don't want to lose their job. Sometimes it's very personal what the information is. Sometimes they're not even aware of it themselves. Sometimes they're fearful they may lose their job. Sometimes they don't have enough personal leave stored up. So they're not going to tell you the obligation sits on the supervisor, okay? Make sure the supervisor gets it. Let's jump on to the next slide. All right. I want to start at the beginning of the statute before we talk about discipline to explain actually what is misconduct and what is serious misconduct. Any action of a person that breaches the how, why, or what is misconduct. Do you agree with that? Every time a person doesn't follow a policy and procedure, every time a person prevents us following through on the KPIs of the organisation, every time somebody breaches a value, every time somebody breaches a law, that is misconduct, okay? I want to be clear about that. There is good, and remember what the common law says, good is 100%. Good's not 85. This isn't an exam and you get through if you pass 55. When you come to work, it's 100%. But is that how we manage people? As I said, I've worked in meat industry for a long time. There's a number of people who are long-standing employees in the meat industry who are not pulling their weight. There's a number of young kids who are working in the meat industry who are actually quite dangerous, often don't turn up to work, and when they do, they're commonly affected by drugs, alcohol, fatigue, disinterested, disinclination. So go back to clarity, capability, and commitment as a real measure of what is good, okay? When someone's not being good, they're being bad, it's misconduct. Now, serious misconduct is summed up by any breach of the common law would be serious misconduct. But particularly any action or conduct that places the business's reputation, the finances of the business, or somebody's personal health at risk is unquestionably serious misconduct. Any person who fails to comply with a lawful and reasonable direction, serious misconduct. Any person who attends work affected by alcohol or drugs is serious misconduct. Now, in serious misconduct, the onus is on you to prove the issue. So we'll talk a little bit more about documents later on, but what I want you to understand is if I don't do good, I do bad, it's misconduct. If I do something which objectively places the organisation at risk, whether it's its reputation, whether it's a financial loss it may sustain, or whether it's the health and safety of people at the premises, it is serious misconduct. And serious misconduct under the Fair Work Act permits summary termination, okay? So that means when someone commits misconduct, we must deal with it. Why? Because otherwise we're caught with the doctrine of condemnation. We can't let it go. Now, think of how you manage your children. You know, they're teenagers and you go, I don't know, I'm not going to pick on them anything because I never stop fighting with them. All right. Well, the reason we have that problem with teenagers is because we step away from the edge. We don't actually have serious discussions around what is good. And we try and comply with them because they scare us, okay? In fact, all of us have had kids and my kids are now no longer teenagers, I can tell you they still scare me. I still walk on eggshells around them because I want them to be happy. Well, I want our staff to be happy, but I want them to know what is good. I'm not fearful of them cracking a wobbly and going to their room and slamming the door, because they're not my children. Okay, there's no loss in my heart when they treat me poorly. So we can define what is good, and when someone is not good, we should deal with it immediately. We'll talk about what is counselling and what is discipline afterwards, but please don't let bad behaviour go by, particularly if it's somebody, and the classic example is somebody who's a high performer who behaves badly. So you've got a leading hand in the boning room who's just great at their job, but treats people shockingly. And you have high levels of absenteeism, and you've got people who are vulnerable, and you're finding that actually the work is being done shabbily by others, but it's all because of the action of the high performing person being a pain and hurting people. It doesn't matter who the person is. If it's not good, it's bad. And if it's bad, it's misconduct, and I must manage it. Now, coming to unfair dismissal, is it harsh, unjust, or unreasonable? That's the test that exists. So I've terminated somebody. The first question to ask is the behaviour that I've done reasonable behaviour? Okay, well, that looks at the circumstances, doesn't it? It says I've got to determine, does the crime fit the punishment? Okay, very simple. Is it unjust? Did I make a decision about somebody and it's actually not true? Did I say I did an investigation and you did this and you couldn't have done it? That's unjust. Okay. And the last question is, would it be harsh? Now, harsh is, I've separated out as a particularly important part of it, because what harshness means is, would the outcome to the person be unfair? The person's been a 20-year employee, never done anything wrong, does something wrong, and I terminate them. Well, the person's got a mortgage, they live in a country town, their wife is very ill, they're 55, there is no other employment for them, and they've been a good employee up to date, and the nature of the misconduct they did was bad, but not really bad. You're never going to succeed in unfair dismissal for that. Okay. I've got a 23-year-old guy with 3 warnings in the past. They do the same thing. Yeah, you're going to be fine with summary termination of that person. So you've got to look at the personal circumstances of the person. You've got to look at their history of employment. And as we talk about how to manage this, how to actually do discipline, we've got to be very careful we listen to people. I spend far too much of my life turning up the Fair Work Commission for clients to be told only a truth that nobody had asked anybody. So I'll be wandering in. I dress a bit better than this when I go along the Fair Work Commission. Not a lot better, but a bit better. And the union official will come up to me and said, you do realise this guy who you've sacked because he drank, his wife left him the night before with his best mate. And yes, he did go out on the grog, and actually he was suicidal. And you've sacked him, and he's actually now, been in and out of mental health institutions because of what you've done. You realise that? And I turn to my client and say, well, is any of that true? And they go, don't know. And it turns out it is. How did we not know that when we dealt with the employee? The answer is nobody likes making the decision to sack someone. They rush the process because they just want to get through. And as they rush the process to get through it, they don't listen. Now remember, when someone does something wrong, the Fair Work Act actually demands of you, as part of an unfair dismissal test, that you put exactly what is the problem to the person, so they know exactly what it is you complain. You give them an opportunity to be heard. Now that means you don't unreasonably deny them the presence of a support person. And if you've got an enterprise agreement which says it's not a support person, it's a representative, you don't deny them the representative. But please take your time. What you're doing when you're terminating someone is changing their life. And that's how the Fair Work Commission see it. They see that you have changed the course of someone's life and caused them harm. And the onus is on you to prove that you did the right thing. So listen, okay? You'll find good things. And if you do the right thing, someone tells you and you find out it's true and you don't terminate, you give them a final warning, but you provide them with support for their family circumstances. You've got a loyal worker, and that person will go out and tell other people how well they were dealt with, even though they did a terrible thing. Now, in professional services, we know that if you do something really good, that client will tell 3 other people of what you did that's good. If you do something that's really bad, we know they'll tell 10 other people. Now, that doesn't explain lawyers' bad behaviour, does it? But it should explain lawyers' good behaviour. Okay, and the important thing about that I'm trying to get across is we know the key to driving good behaviour is the gossip that sits in your organisation. And if the gossip that sits in your organisation says that when Andrew's managing you, if you do something wrong, he's really fair about it. He listens to you, he responds and he supports you, but he will not accept bad behaviour. Isn't that what you want? So remember, gossip's not a pleasant thing, but human beings are tribal in nature, and what holds human beings together is that they talk to each other. So gossip is actually part of how we live. It is a necessary part of how we live, and to ignore the effects of your own bad behaviour is fatal. Now, I want you to think, as your own leadership group that's sitting out there listening today, how often does someone come to you and say, we just sacked so-and-so, can you do the paperwork? And you go, you did what? I'm the person you meant to come and talk to. And as you drill down on what's happened, you find out it's appalling. So there was a discussion that happened in a passageway. The person involved screamed at this person, he's an idiot, and said, just get out. I'm not going to keep you on. Or they came and said, look, you've got a choice. You can either resign or we're going to sack you. Constructive dismissal. They didn't come to the people with skills to find out what was the right way to do it. But worse than that, they didn't find out the truth before they acted. Now, if we want to be good people who are trusted, our job is to find the truth. Our job is not to make mistakes about people's lives. And if we want people to follow us and support us within our business and be good workers, they need to trust us and know that we do good things. Even when we're doing hard things, we listen, are compassionate, allocate sufficient time to listen carefully, and are true to what we say is clarity, capability, and commitment. We make it very clear what is good, and if you don't do it, there is an impact upon you. Does that make sense? Okay, so I want you to understand those principles. They're the ones that sit behind whether you can dismiss someone or not. What is fair under dismissal law means putting the allegations to a person, giving them a reasonable opportunity to respond, not unreasonably denying them access to a support person, giving them time in which to respond, behaving respectfully towards their key elements, okay? Then you've got to look at the personal circumstance. Now, the first question in dismissal is there a valid reason for termination? Okay, and a valid reason is there a reason which, if it is true, would be a proper basis for terminating someone? So just a threshold. So if somebody fails to wear their PPE, so they don't wear the mesh apron and they're working in a boning room, just have a think what that could mean. Imagine the cut injuries you could have, including things like femoral arteries, which are fatal within a very short period of time. So the risk of not wearing that, you'd agree with me, is really high. We might use an example of a forklift loading trucks that drives forward with its tines elevated so it can't see where it's going. What is the risk of that happening and a risk of causing injury? That's massive. So when someone doesn't do something that has the likelihood of serious injury or death to another person, that's a big breach. Okay, it's a big breach. You can't condone it. Next question is a type of action which is called adverse action, which says that an employer cannot treat an employee adversely, that is to their detriment, termination, demotion, those sort of things, because the employee exercises a workplace right. That could be the employee complains about not feeling safe at work because of the bullying attitude of somebody. It may mean because they raise a medical problem that they've got. and you say, no, well, we're not going to make any accommodation for that medical problem. You'd also have problems in discrimination law. It may be because the person is a shop steward and you don't like them, okay, because they have an implied authority by their role. And if I treat them adversely as a result of that, then I'm in trouble. Unfair dismissal. It's only 26 weeks and reinstate. Not good. You don't want to reinstate someone who just sacked. That's the worst thing in the world you can do. But you're not personally liable as a manager. But under adverse action, you are personally liable, as is the organisation, and the damages are unlimited. And the rights that exist for the court to make other orders is very high, including reinstate. Adverse action is not a place you want to be, okay? All right, let's go to the next slide. Okay, discipline and counselling. We've got 19 minutes left. I'll look at my clock, so I better race along. Discipline and counselling are forms of performance and conduct management. They're just different ends of a continuum. So if I'm counselling you, what am I doing? I'm identifying what is good. I'm observing what you did and how that is not good. Where do I go to do that? I go to the key documents that tell me what is good, don't I? I go to the code of conduct. I go to the policies and procedures. You know, whenever I'm about to go and talk to someone for poor performance or misconduct, I go to the part of my documentary structure that tells me what is good. So I can say, I observed you do this. Our business says, good looks like this. It's not what you did. Third question, why did you do it? Now, there may be a good reason. Well, the supervisor told me I had to get those carcasses out quick. Okay, so he's not completely culpable. Everybody else does it that way. I'm not going to be able to discipline this guy. Look, I've never been trained. I'm not going to be able to discipline this person. So please listen why. Don't cut them off. Please listen to what they say. And then you say the magic words, which for either disciplining or counselling are the same. You must never do this again. I'll say that slowly again. You must never do this again. Now, what have I done? I've given 2 lawful and reasonable directions. I've shown how it's to be done in a good way, policy, procedure, code of conduct. I've listened to what you said and I said, you never to do this again, another lawful and reasonable direction. Then the last thing you say is, but let's get you a bit of a help with this and support. So you always, when you counsel or discipline somebody, performance management them afterwards, let's just test the theory. My child comes home late, he's a 17-year-old, and they say, you must be home by 10:30. And I say nothing the next Friday. Will they be home at 10:30? I have to say to them on Friday afternoon as they're going out the door with a pack of cigarettes stuck up their sleeves so I can't see it, even though it's a large rectangle. You need to be home at 10:30. You need to be sober. And I don't want you to smoke too many of those cigarettes. The chance of any of those things happening is escalated enormously by the fact that I had a contemporaneous conversation. So you cannot discipline or counsel someone if you don't follow through and support the changes that you require. And importantly, if people don't do it, you have another shot at it. Good thing, isn't it? How do we get good behaviour? We constantly monitor and manage people to ensure they behave well. So when you're going to counsel or discipline somebody, you are making sure you follow through. Okay. Now, counselling doesn't involve a disciplinary outcome. It is about training someone and educating somebody about what is wrong and setting expectations about what are right. That's what counselling is. Most of your enterprise agreements sometimes misuse the word counselling as a form of discipline, but I don't usually control counselling at all. So if I'm unhappy with you, I can talk to you privately. And that's what I'd do. I'd say, Simon, we need to have a quick chat, mate. Come off the line. You go somewhere private, never in front of other people, because that would be misconduct in itself. I saw you do this on the line a few seconds ago. Here's the standard operating procedure. It's different, mate. Why did you do it? Oh, look, sorry, I was just in a rush. Look, you're not to do that again. If you're in a rush and the line speed's going too quick and the carcasses are coming in different size and some are clean and some are not clean, and that means we have to slow the line down, tell me, do not do that again. And I'll follow it up and let's chat with the supervisor again tomorrow. See that performance improvement? We're going to chat with the supervisor again tomorrow to make sure the same problems aren't happening. I know I'm being watched, okay? Counselling. If it's a low-level thing that's repeated, the last thing you'll say with counselling is, if it happens again, I'm afraid this will have to be elevated to a disciplinary outcome. So counselling is about creating change through influence and conversation. Discipline is about creating change through the threat of losing your job. So when I discipline you, what I am saying is, if you do this again, you will suffer disciplinary consequences up to and including the termination of employment. That's called a warning. A warning that doesn't use those words is not a warning, it's counselling. To discipline someone, you must be saying to them they can lose their job. That's the critical difference, because what you're using is punishment as leverage for change. So you can see how easy why, how, what triangle works, can't you? You go quickly to say, so what's the policies, procedures, what's the code, what are the values, what's the law require? Okay, I've got that. So I prepare before I go and chat to somebody. I need to have absolute clarity about what they should do. I must ensure that they're capable. That is, that they're physically, psychologically capable, that they're competent in accordance to their job description. Their job description is current. And I think the real issue with them is commitment. They're just not trying. Okay, well, now I know what I can say. It's really, really easy. So that's the process that we look at doing. But the thing I want you to remember is I can't look after you without documentation. All right? Julia, we've collapsed up here and there may be some questions that have come through. Sorry, I'm just having a look. No, there's not. It's okay. I just thought I'd have a quick check.
Sorry, Andrew, I might just jump in. There is one question. Ken has asked a question. What is the inherent dangers of being inconsistent with disciplining employees? Kim,
the answer is that's called the doctrine of condonation. It actually came out in a case with BlueScope only 2 days ago. I've forgotten what the name of the case is offhand. It's something in BlueScope, Nolly and BlueScope, I think, where a bloke was using a crane loading coils onto a truck. And he had to be reaccredited every year, and the supervisor who reaccredited him listened to how he described what to do, and they said, yeah, you're fine. They were wrong. And when he did the wrong thing, they went to terminate him. And what the court said is, but you just condoned. He's told you what he's done is wrong, and you weren't listening. You didn't pay attention. You condone bad behaviour at reaccreditation. You can't come now and terminate him. Kim, we see 2 forms of condonation. One is Julia is sitting next to me, so I look like I'm good at technology. Comes in 10 minutes later every day, and Simon, because he wears big earpieces listening to metal music when he should be on the show, he comes in 10 minutes. Simon's my mate. So when Simon comes in late, I'll look at my watch and go, naughty boy, Simon. But when Julia comes in late, I go, Julia, we need to have a really stern talk about this. I'm afraid I'm going to have to give you a warning. Julia could walk along to the Fair Work Commission and point to that and go, different method of treatment, condonation. Okay? It might be that I allow Simon to come in late every day. And then one day I say, I'm going to give you a warning, condonation. I've let it happen every single day. So we see, based on whether I like someone or don't like someone, or whether someone's valuable or not valuable, different methods of treating. The reason I'm talking about why, how, what triangle on the 3 C's is there is only one set of laws that exist in an organisation, and we manage through that. The moment we do individual things, we create condonation, and when we have a condonation, you can't punish what you've condoned. So I hope that answers, Kim. And you will be pulled up, and the union will always run it. Okay. So let's get on to documentation. Let me, because I'm good at talking, but not as much as I have been talking. Stay back where we are. That's fine there. So what I want you to understand is every time you counsel somebody, you need to prepare. What do I prepare with? I prepare with the documents that I need to demonstrate what is good. That's what I go in with. I always take it with me when I come in, all right? Before I go into any counselling or discipline. So I see Julia do something I'm not happy with. I don't just grab her by the scruff of the neck and say, come and have a chat now. I'll go away and have a bit of a think just for 2 or 3 minutes to collect my thoughts. Maybe Julia and I aren't getting on too well. And so I've become more sensitised to what Julia does than what Simon does. Yeah, that happens all the time, doesn't it? I need a bit of breathing space. And if I'm worried, I should immediately go back to people who I trust in the organisation and say, I saw Julia do this. What do you reckon? Why am I doing that? It goes to Kim's question she asked before, okay? If I deal with Julia different than I deal with Simon, what I do with Julia, A, damages her and I lose her productivity, but B, I'm never going to be able to stick with the punishment that I give her. Make sense? So that's the first thing. I prepare my documentation. So I check that I'm being fair. If you're like me and you don't like doing discipline because you don't like hurting people, go and practice with a mate. So I do. If I'm going to have any sort of discussion with someone, whether it's a redundancy, whether it's a termination, whatever it is, I'll usually go and practice with Karen, my CFO, and we'll go and have a coffee and I'll sit down and say what I want to do. And she often says, Andrew, you're responding too harshly. That's not reasonable. I hope that doesn't reflect too badly on me, but you often get too close to issues, and so I'm very sensitive to it. But she'll also act out the other person when we're doing it. So by the time that I go to chat to Julia, I'm comfortable with the conversation, which means she can actually hear me because I'm not angry, I'm not anxious, I'm calm about it, okay? So get your documentation, get your process right, make sure you're following your own rules. Now, something happens in people's brains and it's really important, okay? When people are scared, they go into fight flight. When they go into fight flight, 3 things happen to their brain. 1, they can't hear you. Okay, really straightforward thing. They simply can't work with their brain. What's called their executive function in their brain closes down. So they're listening to you, but it's just not going in. They also lose nuance. So I'm chatting to Julia and saying, look, I'm unhappy with what you've done, Julia. But I'm actually trying to help her. And she's missed it completely because she's in fight flight. And the last part of what happens when people are in fight flight is they go to their own narrative, which is about self-protection. So they go, Andrew's trying to do me over. All right. Now, one of the ways to trip people into fight flight is for you to be very, very anxious when you're going to do stuff because you're in fight flight, which means you're not listening, you're not connected to the person. So you must be relaxed when you go in the room. You should practice, okay? Whenever you talk to someone, either counselling or discipline, either you, or if it's discipline, there should always be 2 people for you when you do discipline, 1 when you're doing counsel. If it's counselling, you take notes, and the notes state date, time, location, people present, and always finish with the time the conversation finished. And then it is at a high level when you're doing it. Julia did these things. I showed her these documents. I asked her why she did it. She said this. Try and capture, don't do this verbatim, but try and capture her actual words, because if you end up in court, there's nothing better than a judge hearing the way Julia speaks coming out in your notes. It's fantastic. And the last thing you write down, and I said it must not happen again, and I followed that up with an email to them later. Okay, now they're the things that I record. When you're doing discipline, you do have somebody sit next to you and you introduce them and say, this is Julia, she's taking some notes. She'll be taking notes of our conversation. And if someone says, oh, can I have a copy of that later? Don't be scared about it, give it to them. It doesn't make any harm. Don't try and be precious about stuff like that. When you create those documents, they're called contemporaneous evidence. And contemporaneous evidence is absolutely critical because what it does is this. It is evidence that you had a conversation, okay? Now that mightn't sound too exciting to anyone, but the amount of times I go along to a Fair Work Commission or to the county court or district court in relation to safety trials or to a VCAT or to some other tribunal for a discrimination claim or the federal court for a breach, everyone denies the conversation occurred. And we're sitting there with no notes to the conversation going, it definitely happened. Now let's talk about our brains just for a second. Okay, we're not going to spend too much time on my old brain, but brains learn this way. They take in information through every one of their senses. It's not just hearing or seeing. It goes into a box in the middle of the brain that spreads it across the brain and locks it into a perception of your history and measures it. So when I see somebody shouting at them, if I've been a kid who's grown up in domestic violence, I see that as a violent interaction. If I grew up in a house like the house I grew up, where people commonly raised their voice in argument, but it was part of how we argued and lived and nobody was nasty to each other, they just spoke strongly, I see it as part of a robust discussion. You see how it happens? Within 24 hours, I have completely changed what I saw, felt and experienced to how it sticks in my brain based on my past experience. But when you create contemporaneous evidence, it's of what happened at that time exactly. And that's why courts love it, and that is why it is an exception to the hearsay rule. In other words, it is evidence of the truth of what happened, and judges will accept it. Now that's great, isn't it? 6 months, 12 months, 2 years later, you go to a trial and your evidence, what you wrote in your book, is accepted. Now, a very important part of books, I don't know if I've got one of my books here, I do. This probably won't help you much and you'll probably struggle to see it, but what happens in my books is everything looks the same. You can't see it, but it's almost unintelligible except to me. But the bottom line is it has dates and times on it. It has who was present. And a judge would pick up that book and go through and go, yeah, he writes the same every day. So it shows it's reliable. And when it's reliable, it will be used as evidence of what happened. Remember, when you're dealing with individuals and unions, you'll be the only person who makes those really accurate notes. So it is critical. The other reason we make notes is so the person who's at the other end of it understands how serious this is. The last part of contemporaneous evidence, of course, is I'm allowed to use that evidence when I go to court. Pretty good, okay? All you do is make notes. And as Simon and I spoke about earlier, it is the difference between a claim being accepted, a psychological stress claim, and being rejected based on your contemporaneous notes. It is the most important thing you can take out of today. It is critical, okay? Please do it. All right, so we know discipline, we know counselling. We know what is good, we know what is bad, okay? The last thing I want you to think about is how do I manage somebody who has a bit of an injury and what am I going to do about that? Whether the injury is work-related or not. The rules around injuries are, whether it's work-related or not, if a person is absent from work for more than 3 months in a year and has exhausted their personal leave, we're entitled to terminate their employment under the Fair Work Act, so long as there is a good reason, and the good reason has 3 elements. They're not capable of doing the inherent requirement of the job, within 2, with reasonable adjustments, and they won't be fit in the foreseeable future. Now, if it's an in-house work injury, it depends on the jurisdiction. So in Victoria, they've exceeded 12 months of a claim. New South Wales, 6 months. It changes between states, okay? You need to know that, okay? Remember, when you do terminate someone who's not fit for work, the impact on the premium can be massive, okay? If it's a workers' comp claim that you terminate someone and they're outside the obligation period, but they've got 2.5 years and 2 years in Victoria, they've got 4 years in New South Wales or Queensland to go, you've kept out your claim for years ahead. So be very careful about it. I just want you to know a little bit around injury management, because what I do want you to know is the obligation under safety law is for you to determine whether a person is fit to attend work. And if you do what I've asked you to do, you will know that. But if you allow someone to come to work and they're not fit, and you see they're not fit because he's the best worker, he's always limping, but he's great, and they injure themselves, not only then do you have a workers' comp claim, you've got a common law claim, and any attempt to terminate that person will ultimately fail. So I hope that's been helpful, Simon. I just thought I'd throw over to you in the last minute or two if there's anything you'd like to say.
Yeah, Andrew, just a couple of things. You talked a lot about, the reasonable behaviour, and I think, in workers' comp we talk about that 2 ways. That, in every state there's a section that talks about reasonable management as a defence against a claim for psychological injury. It's not just reasonable management; it's reasonable management conducted in a reasonable manner. So the process might be sound, but if the way that the person goes about that is belittling and derogatory, then the claim will not be because the person is being performance managed. It will be because of how they were performance managed. And looking at your notes, I know we've both seen cases in the past where claims for compensation based on bullying and harassment have been lodged, and notes have actually proven that what the person is saying occurred did not occur. And when we look at a claim for bullying and harassment, that's probably your only defence, because the legal definition of bullying does not have to be met for a workers' compensation claim to be met. It just has to be that an action occurred.
Yeah, sorry. That's the mistake people keep. They've got to get to this higher level. All you've got to do is breach a rule. All you've got to be is be.
Yeah. Did something happen? One thing. Not a serious thing, one thing. Did the person perceive that in a way that caused a reaction to them? And there is your claim. And so that's why it's so important, your notes to be able to show, well, do you know what? I see what they're saying, but here are my notes at the time, and that actually did not happen. I didn't say those words to them that they're saying I said, or I didn't talk about the topic that they said I talked about. And that's one of the few defenses in that area.
Yeah, and look, that's the other part, Simon, why I said you must go and practice before you do stuff. I've been a workplace lawyer for far too long, which means I've probably dealt with a couple of 100,000 people losing their job that I've been in some part responsible. But every time I deal with it personally, I can feel my anxiety levels go up. I can see myself speaking in a voice which is not my own voice. You've got to practice to be comfortable so that you don't say dumb things. You are in control of yourself, and the person in front of you feels safe.
And focus on them. The last thing you can do is think that the termination is about you or the performance management is about you. I had an example years ago where a manager who'd been coached but didn't pay attention had someone crying during a disciplinary meeting and said these words: "Don't cry. How do you think this makes me feel?" That's not, realistic at that point in time. I don't think that girl actually cared how he felt because she was in danger of losing her job. Yeah. And they're the sort of comments that will lead to a claim.
Not the person you want to be married to either, I just say. All right, look, we're at 2 minutes past 3, mate. I'm sorry I didn't give you much of a chance to chat. Amanda, is there anything you'd like to say?
Andrew, just as a wrap up, there is another question. What should I do if the person storms out of the meeting but doesn't say anything before leaving, or when they storm off the premises, rather than the room? What should I do in that situation?
So the first thing is a person is not allowed to leave the premises without permission, okay? Because their job is to be at work. When a person gets up to leave, you should always say, look, I'm giving you a lawful and reasonable direction, that is to sit down. I'll give you some time to calm down. I'll take a break for 2 or 3 minutes. The person, I'm going. So look, please don't go, because if you go, I'm afraid that's going to be a disciplinary issue. You are not to go, but I'm happy for you to stay in here and I'll step out and give you time to calm down. If a person does leave the premises without permission, it's serious misconduct, okay? Now remember, at that stage, you don't go and shoot them because that's overreacting. And I mean, if you do go and shoot them, that would genuinely be overreacting, but you don't go and terminate their employment either. What you do is when they come back in the morning, you say, look, your obligation is to be at work between these hours. You left work without permission. That's clear breach of the obligations. I want you to explain to me why you did that. I was really angry. All right, well, let's talk about that. When you're really angry, you're entitled to say, I'm really angry, and I'm entitled to say, okay, you can have a break for a few minutes to think about it. But be really clear, if you ever behave like that again, you'll be summarily terminated. Why am I not terminating them? Because they've committed serious misconduct, because you'll lose when you get to the commission, and because it's the wrong story to go back to the start, because every now and again, for reasons none of us can understand, we respond badly. Now, that might be the guy whose wife left him for his best mate the night before. Do you know what I mean? There could be a million reasons why that person left. So the most important thing is, as they get up to go, give them the direction to stay and say, you stay, I'll pop out for a few minutes. I'll come back and check if you want a cup of coffee or tea in a few minutes' time, but just calm down, okay? If they leave it as they go, say, you can't do anything about it, you don't ever try and stop someone from leaving a room physically. Don't stand in front of the door because that's called false imprisonment. Don't touch them because that's actually called assault, okay? Let them go. When they come back the next day, manage it in the way that I've done. Make very clear to them if it ever happens again, they'll lose their job, and listen to them as to why they did it and give them some skills so it doesn't happen again. I hope that helps.
Great, thanks, Andrew. Well, on behalf of AMPC and everyone that's been listening, thank you, Andrew, for giving your knowledge in this area today, and to Simon as well. This, as I said at the beginning, this is the first one of a 4-part series in our work health and safety webinars. The next one is scheduled for the 28th of May at 2 o'clock again, which is managing serious injuries and fatalities. So we will send out some information and a registration around that closer to the time. So thank you everyone for participating. when I close off this webinar, you should get a survey. Really appreciate it if you could spend, it'll only take you maximum 2 minutes to complete the survey, but it will give us some valuable feedback to make sure that we can continue to improve these as we roll through all our webinars. Thanks very much for today.
Thanks very much, Ben. See you later. Bye-bye.
Yeah, bye.